You are on live, sir. Go ahead, sir. Sir.
Good evening to all of you.
Unmute chain, madam.
Good evening to all of you.
No. Unmute chain, madam.
Yesterday, we were just discussing about declarations. In declarations, we forgot to discuss 2-3 things. One is, as far as there are, if you see the court fee section under which court fee has to be paid as far as declaratory suits are concerned, it is section 24. 24 consists of 4 parts. One is declaration and possession. Declaration and possession. When you are not in possession, then the question is you have to pay 3/4 of the market value as far as the declaration suit is concerned. But if you are in possession, 24A says that you can file a suit for declaration and possession under 24A and pay half the market value. 24B, if you are not in possession, you can ask for declaration and possession and pay court fee at the rate of 3/4 of the market value. C is, as far as copyrights and IPR suits are concerned, there is a fixed court fee for that. Then 24D, if the suit is incapable of valuation, then we fall back on 24D and value it accordingly as per the market value or 300 rupees or whatever is fixed by the court. Then I also told you that a suit for declaration can be filed only when you are not a party to the suit and when you want to challenge the instrument or challenge the decree which is passed by the court. A suit for declaration would lie under 34 and 35. But the essential ingredients of 34 and 35 is you must assert a right, position, cadre, and status, and that should be denied by the other side. And if you assert and denied by the other side, then a suit for declaration would lie under 34 and 35. Please remember this is an essential ingredient as far as 34 and 35 is concerned. I have also gave you the various facets in which the suits are filed under 34 and 35 of the Specific Relief Act. Then we now pass on to a very important chapter called Law of Injunctions, which is laid down in section 37, 38, and 39. 37, 38, and 39. When I was discussing about Civil Procedure Code, I gave you an account of injunctions as laid down in Order 39. But here, the actual rules which apply for grant of injunctions or the principles of injunction is laid down in the Specific Relief Act, section 37, 38, and 39. Now, there are how many types of injunctions, sir? One is interim injunction, another is temporary injunction, another is perpetual injunction, and another is mandatory injunction. As far as temporary injunctions are concerned, they are governed by the Civil Procedure Code, to be more precise, Order 39, Rule 1 and 2. As far as ad interim injunction is concerned, it is covered by the Civil Procedure Code alone, but the principles which govern injunctions are again laid down in the Specific Relief Act. Let us go one by one. What is actually an injunction? How is an injunction defined? Injunction is defined as a prohibitory order or a preventive order which restrains a mischief which is committed, about to be committed, threatened to be committed, apprehended to be committed. Then we say any suit for injunction can be filed. Here, as far as we are concerned, whenever the matter is urgent, what we do is we file it with a out of order petition. You know under what provision out of order is filed? It is filed under section 151 Civil Procedure Code. In this regard, I would like to alert you, there are some people who are appearing from Karimnagar. In Karimnagar, there is a notice or circular already given. You shall not file printed forms. You shall get it typed and then file. Printed forms are not accepted as far as Karimnagar district is concerned. That was a circular passed when Mr. Parthasarthi was the principal district judge in Karimnagar. That is being followed even today. Because I found that difficulty when we went there to file a suit. We filed the printed form. They rejected it and said, please get it typed and file it. So that you have to you have to be alert on that. But as far as our twin cities are concerned, Rangareddy district and all are concerned, we file printed forms. Because we have got used to the printed forms, you only fill up the columns and then file it. But please bear it in mind, when you file an out of order, there are some judges who try to avoid as far as granting out of orders are concerned. Why? Because it multiplies their work. And there you'll have to state the reasons why the matter is urgent, why you want urgent orders, why you are filing the application for out of order. All these things you have to explain. And there are certain judges who just blindly sign check and put up. But now some judges who are there who expect that you have to explain why the matter is urgent. To cite an example, we have got a principal district judge in Malkajgiri, the present principal district judge. You have to explain to him as to why the matter is urgent, why an out of order is required, what are the facts of the case, why it requires urgent order, so on and so forth. Unless you explain to him, your out of order will not be accepted. Of course, we have got that's why I said it's said justice varies according to the foot of the chancellor. So the question is, you have to be well prepared. Don't blindly file an out of order. But nowadays we find the plaintiff is not prepared in the office. Normally, what happens is only a skeleton papers are prepared, and initially juniors are sent to move the out of order at 10:30 till 12 o'clock. You can move the out of order. After 12 o'clock, they don't accept. Once you move the out of order, please remember there are some judges who are very, very conscientious. They say, sir, where is the original bundle? If you don't show the original bundle, your out of order will not be accepted. But normally judges pass it on in a normal manner, in a prudent manner. So the question is, whenever you require urgent orders, whenever the matter is so urgent that you require interim orders, then in that case, you move an out of order under section 151. What does 151 say, sir? It is the inherent powers of the court. Petition accompanied by an affidavit. Along with that, you file the suit bundle also. Here, in this regard, I would like to tell you what are the papers you file here and how you avoid court fee also. Here, suppose you file a suit for injunction, the papers which you file is under Order 6, Rule 1, the plaints in duplicate, and one extra copy for the computer for scanning purposes. Along with that, an interlocutory application which you file for urgent orders, that is under Order 39, Rule 1 and 2 CPC, accompanied by an affidavit. Then along with that, you file what is called a verification affidavit under order 6, Rule 15, bracket 4. Then you also file what is called, nowadays the courts are insisting on filing an affidavit under Order 6, Rule 14, saying that you give the addresses of the parties and say, and that the addresses given above is true and correct. Then in Andhra area, I've seen you have to file another affidavit also under section 26(2), saying that again it's in the form of a verified affidavit, saying that the facts stated in the plaint are true and correct, and it's made with a lot of restraint and responsibility. But of course, here in city, they don't insist on that petition. But in Andhra area, that petition has to be compulsorily filed. Then along with that, you pay the BATA. That is the process you pay. That is, along with the process, you affix the necessary court fee, fill up the process form, that is Form 61, as far as the civil rules of practice is concerned. And there you fill up the process form, fill up the addresses of the party, and then pay the necessary court fee as far as process is concerned. And along with that, you are supposed to pay even the process under the registered post. And what are the forms you file in a civil suit, sir? That is called Form for Settlement of Issues under Order 5. The printed forms are available. You can file printed forms. And in case there is only one defendant, you file 3 forms and then pin it to your process. And along with that, under the civil rules of practice, copies of the petition, plaint, whatever you have filed, has to be attached to the process. And as far as the interlocutory application is concerned, where you have asked for interim orders or temporary injunction, you file what is called the process as well as the notice for show cause general. That is only in duplicate you file for each party, and then you pay the necessary court fee. Here you must remember one thing: you can adopt two procedures. When you try to fill up a process form, try to keep a carbon so that you need not write it again. Only thing is, if for the carbon process, you write IA number of 2024 or whatever it is in whichever suit it may be. The question, along with that, when you file a suit in respect of immovable property, you have to file what is called Form number 8. That is, Form number 8 is valuation of property. That you fill up the necessary forms, take your client's signature, and then file it. Then, along with that, you also file what is called the documents on which you rely. That the suit documents have to be filed in original, or you can file what is called certified copies of the documents. Please remember, Order 7 clearly says all suit documents have to be filed along with the plaint. And also, you have to provide as many copies as there are defendants for the purpose of the defendant knowing your documents and then answering it accordingly in the counter which he is going to file. Then again, the question is, I also, when I discussed civil procedure code, I said, what are the consequences if you don't furnish the copies? Naturally, sir, the Nazarat is the most notorious section. What they do is the process server carries only a small bag. I think you must have noticed it also. In that, only the summons will be there. Plain copies or the petition copies will not be there, or the documents will not be there. But if you go and check up the dustbin of the Nazaret section, you find all your plains, petitions, and all dumped in the dustbin. This is the unfortunate situation in civil law. But in criminal law, what happens is, I think most of you or some of you are practicing on the criminal side, know that the copies are served only when the accused appears in the court and it is served and his signature is taken. That's a better process, because there's no chance of the papers being thrown in the dustbin. Please remember, the real difficulty comes when you appear for an institution. Suppose there are 15 parties or 20 parties, sir. The practical difficulty which we people face is the bank will pay you or the institution will pay you only 2 times. The other times you have to pay from your pocket. So the question is, the civil rules of practice says whenever process is paid, the copies of the papers have to be affixed, has to be enclosed along with that, and without that, you cannot do it. Then one more precaution you have to take, sir. Whenever you file a suit, your suit, all of us, every scrap of paper which you file, wakalat, so on and so forth, will be entered in a book called the SR register, stamp register, which is kept and maintained by the court in the regular course of business. So, what is the advantage of your plaint being entered in the SR register is it's prima facie proof that the papers have been filed and it has got a particular accession number. And whenever you want to trace out your file, you can definitely go to the section and say, sir, this is my SR number. Please tell me whether my suit is numbered or not. If you don't know the SR number, please remember it will be very difficult for you to explain to your seniors. Then, sir, once the suit is filed, what happens is, I'll come to injunctions after this, please. It is entered in the SR register and it is checked by the Sarasada or the CMO. He makes his own notes, and nowadays printed forms are available. He fills up the necessary columns and also places it before the allotting judge for the purpose of getting it registered. Then the allotting judge goes through the papers and then endorses, please register the suit. Then it is entered in a suit register with all contents, and then next thing is the caveat register will be checked by the section. If there is any caveat filed by the opposite party, it will be noted that caveat filed on so and so date regarding a particular property. This all, and then once the suit is numbered, it is entered in a register called the suit register, and the allotting judge may retain the file with him or allot it to some other judge who is also his co-judges. Like suppose you say first junior, He may allot it to second junior, he may allot it to third junior, fourth junior, and a date is also fixed for appearance of the defendant. But suppose in injunction, suppose you file it with an out of order, it is checked by the section. K-weight register is checked. It is placed before the judge. Judge enlarges saying that register the suit. It is entered in the suit register. K-weight is checked. A note is also put up saying that no K-weight filed. Again, it comes back to the allotting judge for the purpose of necessary orders. And before the allotting judge, you go and then advance your arguments, or it is heard. So this is a long procedure as far as filing of suits are concerned. Now we come to the injunctions in the proper perspective. There are four types of injunctions. One is called interim injunction, another is called temporary injunction, another is called perpetual injunction, another is called mandatory injunction. These are the four types of injunctions. What do you mean? Let us go one by one. Interim injunction. Interim injunction means where the matter is so urgent, issuance of notice to the other side will frustrate the very purpose of the suit, and the judge gives a reasoning order and giving reasons why notice is not necessary. No issuance of notice will frustrate the suit. He passes a lengthy order saying that a prima facie case is made up, and then it's a balance of time, so on and so forth, and issues what is called an interim injunction. Don't think that temporary injunction is ordered immediately when you file a suit. First, you go through the different stages. Interim injunction is granted. The word interim itself means an injunction for a limited period of time to give an opportunity to the defendants to come and appear, file their counter, file their documents, and they should be heard before an order is passed. Then interim injunction is granted only for a limited duration of time. Let us say today we are on 9th. Suppose I file a suit today, injunction will be granted up to 12th or 13th. Then what is my duty, sir? Normally the other side appears on 13th or so. And on that day, suppose the other side only files a wakalatnama but does not file the counter. Your duty as an advocate for the petitioner is to file a memo or file a petition for extension of time, extension of the interim orders. Please remember, if you fail in your duty in not filing an extension petition on the day when it is fixed and the injunction is operative, only up to a particular date, the injunction works itself out. So interim injunction is not permanent. It is only for a limited duration of time, and that too, the judge has to pass the order by giving reasons why interim injunction is granted. But I told you also, so far so good. Before the CPC was amended in 1976 by Act 46 of 1976, injunctions used to be granted just for mere asking. But after the Act of 46 of 1976 was passed, the Order 39 was amended, whereby they said just by mere asking, injunction should not be granted, interim orders should not be granted. Under the principle of adi alteram partem, the other side also is to be heard, and then alone the injunction can be granted, not otherwise. So now our hands are tied, and that is the reason the courts to escape the liability. If you insist too much, they pass a status quo order. That status quo means things stand where they are. Things stand where they are. But the conditions which you have to perform is once an injunction is granted, or let us say an interim injunction is granted, you have to send the copies of the plaint, copies of the petitions, copies of the affidavit, copies of the documents to the opposite side by registered post and file an affidavit under Order 39, Rule 3, that is called compliance affidavit under Order 39, Rule 3, saying that the copies have been dispatched to the opposite side by registered post and the postal receipt is enclosed along with that affidavit. Please bear one thing in mind, unless you file that compliance affidavit, your injunction will not be communicated to the opposite side. Then, once the other side appears, other side files the counter, other side files his documents, you are heard, and the other side is also heard. Once the hearing takes place, please remember judges are now under the duty, whatever documents are filed along with the petition or along with the plaint, they have to be marked even in an interlocutory application as exhibits, so that the court is guided as to what are the documents that have been filed by the respective parties. If you are the plaintiff, it is numbered as, it is marked as A series, and if you are the defendant, it is marked as B series. Please bear it in mind. Even if the court forgets it, please request the court, sir, please mark my documents as exhibits. Or before you start your arguments, mark your documents before you start your arguments. Please remember that is the safest mode so that the court may not miss any document while discussing the matter. Are you able to understand, please? Then, once the interim injunction is the IA is heard. IA means interlocutory application. Any application that is filed along with the suit, which is miscellaneous in nature, is called an interlocutory application. An interlocutory application shall always be by way of a petition supported by an affidavit. Then, once the arguments are heard on both sides, that is, as far as the petitioner is concerned and as far as the respondent is concerned, the court passes an order. Please don't say judgment. Court passes an order allowing the application or disallowing the application. Allowing means your injunction, which is already granted, will be made absolute and your petition will be allowed. If you do not satisfy the court that that you have not made out a prima facie case, your petition will be dismissed and the injunction already granted will be dissolved. Then, of course, you are not without a remedy, sir. We don't end with the lower court. You have got the right of filing an appeal before the appellate court under the provisions of Order 43, read with under Section 104, read with Order 43, Rule 1, bracket R. Even if the petition is allowed or petition is disallowed, you have got a right of appeal to the appellate court, district court, or high court, as the case may be, under Order 43, Rule 1R, read with Section 104. Then that is called a CMA. CMA means Civil Miscellaneous Appeal. Then what are the grounds you mentioned there, sir? What are the points, findings of the lower court which is perverse? Where the lower court has not taken into consideration the volume of documents what you have filed, or the lower court has not not agreed with your arguments, or the lower court has misinterpreted the exhibits that you have filed, or the lower court has not gone into the precedents which you have cited, or there are inconsistencies in the findings of the lower court, then in those circumstances, once a CMA is filed, CMA means Civil Miscellaneous Appeal, the court calls for the records of the lower court, and then once the records come to the lower court, from the lower court it comes to the appellate court, and in the meanwhile they issue notice to the respondent fixing a date for hearing, and the respondent appears, files a wakalatnama entering his appearance, and once mere filing of a CMA does not operate as stay of all further proceedings before the lower court. So to be on the safe side, you file a stay petition also under Section 151 CPC. There is no other provision, please. Asking the appellate court to stay all further proceedings in the suit till the disposal of the appeal. Then in that case, the appellate court, if it is satisfied with your application, it stays, that means it keeps under suspended animation all the further proceedings before the lower court. Then the question is, once the interim, let us go one by one. Suppose your interim injunction is made absolute, then the interim injunction gets converted into temporary injunction. The interim injunction gets converted into temporary injunctions. It will be operative till such time your suit is disposed of. When you file an appeal, when the other side or you file an appeal, when you are aggrieved by the orders of the court, suppose the appellate court is seized of the matter, it calls for the records. Here's both the parties, it has got the right of what is called allowing the appeal, setting aside the orders of the lower court, confirming the appeal, confirming the orders passed by the lower court, varying the orders of the lower court, or modifying the orders of the lower court, or remand the matter back to the lower court for fresh disposal. But here, sir, suppose, let us say, you have come across a change of law or subsequent documents which has got a material bearing on the case, then what is the provision under which I have to introduce these documents? Please remember, most of us or most, why even people with established practice file it under Order 7, Rule 14.2. Please remember, Order 7, Rule 14.2 does not apply to the appellate court. What you have to file it is, you have to file it under Order 41, Rule 27 CPC, inserting these additional documents by giving a copy to the other side. Then once the matter is heard threadbare, the appellate court has got the power either to set aside, either to confirm, vary, modify, or remand the matter back to the lower court. So now, sir, which order will work, sir? Will the lower court's order work or the appellate court's order work? I mean, just visualize. Suppose the order of the lower court is set aside, what will happen to the lower court order, sir? Lower court order, the appellate court order merges with the lower court, and only the appellate court order will be interpreted or will be followed. So once the interim injunction is granted, it is argued by both the sides, it is appreciated by the court, and the court agrees with the petitioner, it allows the petition and makes the injunction absolute, or injunction application is allowed. Suppose it disagrees with the petitioner, it leans more towards the respondent, then the injunction application will be dismissed. Then what are the consequences, sir? When you are aggrieved, you can definitely file an appeal under the provisions of Order 43, Rule 1R, read with Section 104 before the appellate court, either the district court or the high court, according to these circumstances. So, interim injunction is when hearing is done on both sides, matter is heard by the lower court, threadbare, the interim injunction gets converted into temporary injunction. Then we come to the next stage. Are you able to understand, please? When interim injunction becomes temporary injunction will be operative till the disposal of the suit, no need of filing a fresh application. Then after that, the next stage is reached where, suppose the written statement is already filed, then court frames the issues under Order 14, Civil Procedure Code, and then directs the parties to file in the court the list of documents and the list of witnesses before the court within 3 weeks or 4 weeks or whatever it may be. Then after that, according to the chapter on burden of proof and the Evidence Act, the plaintiff starts the evidence. He files his chief examination, and and please remember now, according to the amended CPC, all evidences in chief shall be filed by an affidavit. And the documents which are filed along with the chief affidavit is marked by the court, and the next process is the cross-examination will either be recorded by the court or delegated to an advocate commissioner to record the cross-examination and file a report into the court. Then once the plaintiff exhausts all his witnesses, then it comes to the defendant side. Defendant, please remember, first the party has to examine himself, not the witnesses first. Parties have to examine themselves, then come the witnesses. Then if the defendant is there, defendant has to examine himself and then the witnesses. But there is some emergent provision under the Civil Procedure Code which says that even when, suppose the witness may not be available tomorrow because he's a permanent resident of USA or Russia or Ukraine, let us say, which is in war, he has come there, then you can say, sir, please record his evidence immediately before you take up my evidence. In extraordinary circumstances, the court can take up the evidence even before the parties are examined. Then once the evidences are laid on both sides, exhibits are marked, and then the arguments are heard on both sides, and then written arguments are also filed. Please remember, I still remember when I entered the practice, we used to argue matters for days and days together. One day 4 hours, one day 4 hours, one day 4 hours, one day 3 hours. But those days are gone now. CPC has been amended where they say court can restrict your oral arguments, and say, sir, please finish your arguments within 1 hour or 1.5 hours. And if you so want, you file your written arguments. And written arguments provision also has been made, Order 18, Rule 2, bracket 3, which says within 7 days from the date of culmination of arguments, written arguments can be filed on either by both the sides, and the court takes it. Then once the matter is heard, the court proceeds to pass the judgment either in favor of the plaintiff or in the favor of the defendant. Once it decides it in favor of the plaintiff, It says the suit of the plaintiff is hereby decreed with cause or without cause, whatever it may be. Suppose the court does not agree with the plaintiff, the court says the suit of the plaintiff is hereby dismissed with cause. So, what are the stages, sir? Interim injunction is granted when the matter is urgent. It is given as a temporary measure, provided sufficient reasons are shown by the judge saying that issuance of notice to the other side will frustrate the very purpose of the suit, and the interim injunction is valid only for a particular duration of time. The other side is called upon to file his counter and the documents in support of his defense. Then after that, the application is heard and the exhibits are marked, and after the hearing is over, the court passes an order as far as the injunction application is concerned. Once it agrees with the plaintiff, it says the petition of the plaintiff is hereby allowed. That means the injunction already granted will be made absolute, and then the injunction, the interim injunction gets converted into temporary injunction. Then after that, I told you also, if either party is aggrieved, definitely they can file an appeal under the provisions of Order 43, Rule 1R, read with Section 104 CPC. And then once the appeal is filed, notice is issued to the opposite side, then the appellate court calls for the records of the lower court, fixes a date of hearing, and then hears the arguments on either side. And if the court is satisfied that the lower court's order is fallacious or faulty, it sets aside the order. Or if it finds the easiest mode is to confirm, because you need not burn your midnight oil, or vary or modify the orders of the lower court, or remand the matter when fresh issues arise. And if additional documents have to be filed, they have to be filed under the provisions of Order 41 to 27 CPC. For special reasons, it can be allowed. So after the evidences are laid on both sides, the court proceeds to pass a judgment. And under the CPC also, I told you within what time the court has to pass. Previously, we used to have judges who used to dictate it immediately. In the High Court, it happens, but in the lower court, they reserve it for judgment. But under the old CPC, 14 days time was given to pass the judgment. Then slowly it was enhanced to 30 days. And today, according to the amended CPC, 60 days time is given to the judge to pass a judgment. Then after that, 7 days time is given to file the MC and FC. MC means Memo of Cost and Fees Certificate. And once the advocate certifies the fees and the amount that is spent for the plaintiff, so on and so forth, that will be mentioned as plaintiff's cost, and the defendant's cost also will be mentioned. Whoever has to pay the cost also will be clearly written, so on and so forth. Then in the decree, everything will be mentioned. What is the scope of the decree? Who has to pay whose cost? How much? What is the order that has been passed by the court? Everything will be summarized in the decree. And normally, when the FC and MC is filed, the decree is prepared. But please remember, the date of decree will be the date of judgment alone. And what is executed in a civil court is only the decree. Order 21 says execution of decrees. It doesn't say execution of judgments. It's only execution of decrees. But now provision also has been made to enforce, implement the decree for injunction. That is Order 21, Rule 32, CPC. And also the extra provision also is there under Section 151 to implement the orders. The court will not go and implement it. You can ask for police protection, and the police will implement the orders for and on behalf of the court. This is the entire gamut of interim injunction and temporary injunction. Interim injunction is governed by the Specific Relief Act. As far as temporary injunction is concerned, it is governed by the CPC, that is Order 39, Rule 1 and 2. Then I also told you regarding perpetual injunction. Then the last type of injunction is mandatory injunction. The word mandatory injunction, the word mandatory comes from the word mandate. Mandate means command, order. That is, it promotes what is called activity. It wakes up a person from slumber. That is, suppose a public authority is sweeping over the rights of a party, does not take an action immediately, in spite of several representations, the court will compel them to do their duty, what they have omitted to do. That is what is called mandatory injunction. That is, mandatory injunction promotes activity, perpetual injunction promotes inactivity. Are you able to understand, please? Here, under what circumstances a mandatory injunction is granted? Mandatory injunction is granted. Suppose, let us say, the plaintiff, in addition to the perpetual injunction, also asks for removal of some unauthorized structures or removal of the encroachment that has been made, or construction where certain parts of your property has been encroached by the opposite side, to remove that encroachment or to remove that obstruction or to remove those offending structures, or if they don't do it, the court itself will order those structures to be removed. That is what is called a mandatory injunction. Or let us say ingress and egress has been prevented. Or let us say you have obtained an injunction, but still the other side stops you from passing through that particular thing. Then in that case, the court can pass a mandatory injunction directing him to remove the encroachment. Or if he doesn't remove it, department will be removed, and the cost of the removal will be recovered from the defendant. That is what is called mandatory injunction. Suppose, let us say, a landlord wants to get rid of his tenant. One of the easiest ways of getting rid of a tenant is trouble the tenant as far as possible. Remove the electricity meter, direct the electricity department to disconnect the electricity, not to give power to that to that particular tenant, or directly or give instructions to the HMW SSB, which is supplying drinking water, to stop the water supply as far as the tenant is concerned, or remove the fuse, remove the electricity meter, and the tenant has been regular and prompt in paying everything, and he has been regular in fulfilling his obligations. But the landlord wants to get rid of the tenant and then remove everything. Then the tenant can say, please direct the other side to put all those things in the same position as it was before it being removed. That is what is called mandate. Then, sir, what are the ingredients that have to be satisfied for the purpose of grant of injunction? Injunction was what is called an equitable relief. Injunction cannot be granted as a matter of right. There are three ingredients which have to be satisfied. One is prima facie case. Prima facie case means a case based on facts, based on documents, where you have got a triable case. Then it is called a prima facie case. Then balance of convenience. What do you mean by balance of convenience? Means where the advantage that we cause to you will outweigh the hardship that will be caused to the other side. Then it is called balance of convenience. Then what do you mean by relative hardship? That is the difficulties to which you will be put to in case injunction is not granted. It is called relative hardship. All these three ingredients will have to be satisfied for grant of injunction. So the earliest case decided on this aspect was AR 1963, AP 365. That was the judgment rendered by Chief Justice Chandra Reddy and Justice Shesha Chalapati, who reiterated the provisions and ingredients of grant of injunction, and also laid down the guidelines under which injunction can be granted. Of course, this has been followed by all the Supreme Court judgments, which says that these three ingredients are the sine qua non or necessary ingredients for grant of injunction. So these are the four types of injunctions, sir. And mandatory injunction is not granted. Please bear one thing in mind. Mandatory injunction is not granted by CPC. Mandatory injunction is granted only under Section 39, Specific Relief Act. Perpetual injunction is not granted in CPC. Perpetual injunction is granted only under Section 38 of the Specific Relief Act. And interim injunction and temporary injunctions are granted under the Civil Procedure Code, that is Order 39. So this is as far as injunctions are concerned. I still remember when I was lecturing in the law college, the Usmania University Day College, a particular lecturer was asked periodically by a student, like one of you, sir, what is the difference between an injunction and a stay order? Then the particular lecturer said, sir, it involves a lot of complications, sir. I will let you know tomorrow by studying the book. The same student on that next day caught up and said, sir, please tell me what is the difference between an injunction and a stay order. Then he said, I have not read it in detail. I will explain to you tomorrow. The third day, the same student asked him the same question. He said, why are you asking this question again and again? Are you testing my knowledge? Then the student shot back like one of you to say, నీకు తెలియకపోతే తెలియదని చెప్పరాదురా బాబు, ఎందుకు నువ్వు మమ్మల్ని 3 రోజుల నుంచి నాకు దానికి సమాధానం ఇవ్వట్లేదని. Then he wanted to escape by saying, I was teaching CPC there. He said, you ask your CPC lecturer, and since he is also an advocate, he will give you a practical exposition of an injunction and a stay order. But for me to explain this, injunction, that is stay order, emanates from an order already passed, which is a fait accompli, where you want it to be kept in suspended animation, or where you want it to be stayed till the appellate remedy is exhausted, it is called a stay order. That is where an order is already passed against you. And that order you wanted to keep it in suspended animation till such time your appeal is heard. That is what is called a stay order. Are you able to understand, please? What is an injunction, sir? Injunction is you don't want to ask for a stay, but you want to restrain the other side from doing a wrongful act which is done, about to be done, apprehended to be done, or expected to be done. That is called an injunction. Injunction is a restrictive relief whereby you prevent the other person from committing a mischief. But stay order is where there it is in injunction, no order is passed, but you want the court to pass an order to restrain the other side, prevent the other side by restrained order. But in stay, order has already been passed against you, but you want that order to be kept in suspended animation till such time your appeal is heard. That is called a stay order. That is a basic distinction between an injunction and a stay order. Next, we go to section 47. In a suit for injunction, in lieu of or in addition to injunction, damages can be claimed. That is, suppose, let us say, the harassment that has been caused to you is so great, is so grave, you have suffered mental pain and anguish, but for the injunction, the other side would have continued with this mischief. Then you can say, for the mischief committed by the other side, sir, please also award damages, that is by money compensation for the wrong done by that person. So section 40 says, in addition to injunction, you can also ask for damages. But please remember, if you do not ask for damages, court will not grant you damages at all. Because once a child is hungry, it alerts the mother by crying, saying that I'm hungry, please feed me. In the same way, when you go to the court, when you want damages, in addition to injunction, not that you should go and pay, but you should also ask for damages. Court can, in addition to injunction, can also grant damages as far as section 40 is concerned. But suppose, let us say in the plaint, later on you notice that you have not asked for damages, court can permit you to amend the plaint and ask for damages. That is permissible under section 40 specifically. Then we go to in what circumstances an injunction cannot be granted. That is section 41. It says, 1. Restraint of civil proceedings unless to prevent multiplicity. Sir, please remember, suppose, let us say, a person has got a right to go to a civil court. I cannot stop him by taking an injunction. Let us say, my admin, Mr. Kalyan, cannot file a suit against me in respect of the document which he has obtained from me. Or he cannot go to court at all. He cannot approach the civil court for redress. Or he cannot file a suit at all against me. That cannot be ordered, because as far as I'm concerned, when I've got a legal right, when I've got a right which is enforceable under the law, when I can seek redress from a civil court, none can stop me from filing a civil suit. So an injunction cannot be granted. An injunction cannot be granted unless to avoid multiplicity of proceedings, to restrain a person from filing civil proceedings. Next one is prosecuting any proceeding in any court not subordinate. For example, suppose, let us say, I've already filed a suit in the district court, and in injunction application or injunction suit is filed in the lower court. There is a junior civil judge. Junior civil judge is supposed to be subordinate to the district judge. So the question is, I cannot file a suit in a court which is subordinate to the court where a comprehensive suit is pending. The third one is, you cannot prevent me from prosecuting, from applying to a legislative body. Please remember, any free person who is an Indian citizen can offer himself for election to the legislature, to the legislative council, parliament, lower house as well as the upper house. And as far as the ZTPC and all these things are concerned. But here, subject to the rules prevalent under the Representation of People's Act, I think the latest writ petition, in the High Court, which is filed against the working president of the BRS, who got elected from Sirsila. When you file an election affidavit, you have to disclose all the assets and liabilities, and also disclose as to what are the assets filed by your dependents. In that particular affidavit, it was alleged in the election petition that the person concerned gave his election affidavit whereby he said, only my dependents are my minor daughter and my wife. My son has got his own means of livelihood. He has earned about 65 acres of land at Siddipet. He has got houses in foreign countries, and so on and so forth. Please remember that child was only 15 years at the time when these properties were acquired. How could a child acquire so much of property unless he has got financial support from his father? So those are the grounds which are made in the election petition. And he said it is a violation of the Representation of People's Act. Even otherwise, unless a person is convicted and suffering jail sentence, he cannot offer himself for election. But still, if he is free, now the Supreme Court also has clearly laid down, saying that unless you are convicted, unless the charge sheet is filed and you are convicted of the offense, you can offer yourself for election. So no one can prevent anyone by an injunction not to offer himself for election. Then next one is restraint from instituting criminal proceedings. That is, suppose a criminal offense has been committed and that offense is punishable under the court, and now I think now it's called BNS. Then there is Bharatiya Nyaya Sanhita. Then in that case, I cannot stop him from going to a criminal court or lodging a police complaint against me, or prevent him from initiating criminal proceedings. Then to prevent breach of contract, the performance which cannot be followed, that is enforced. For example, suppose you go to a surgeon for an operation, and the day of operation, let us say the surgeon is suffering from mental and physical disability, he is unable to perform the contract, specific performance cannot be ordered. You cannot compel him, please come in the wheelchair or come with crutches and perform my operation. An injunction cannot be taken for that particular purpose. Then to prevent on ground of nuisance, which is not nuisance. For example, of course, perhaps when this specific relief act was passed, we didn't have the nuisance of noise pollution. Now, once you have these ethnic festivals, the loudspeakers are blaring sound comes out of the loudspeaker. Please remember, the worst type of pollution you can talk about is noise pollution, which breaks your eardrums or your eardrums burst. But the question is, suppose in the opinion of the court, it is not a nuisance at all, then such an injunction cannot be granted. Then to prevent breach in case of acquiescence, that is, you yourself acquiesce, you yourself pollute, you also want that wrongful act to become. Suppose, for example, you have got, let us say, inflammable substance like gunpowder or crackers to be stored in your place. Then let us say there's an explosion. You cannot complain and ask for damages or ask for injunction, saying, sir, damage has occurred because of the blast. I want damages. That cannot be done, or you cannot ask for injunction also when you yourself pollute with the other side in committing a particular thing. Then next one is when alternate efficacious remedies are available. For example, you cannot file a suit for injunction when you have an effective relief of asking for specific performance. Unless you ask for specific performance, you cannot ask for injunction. So an effective remedy is available, alternate remedy is available, efficacious remedy is available, then in that case, you cannot ask for injunction. Then when conduct of plaintiff or facts has to be such so as to suppose the conduct of the plaintiff is abhorrent. That is, he is himself something calling the kettle calling the pot black. He himself is the fault who has committed the fault, but he calls the other person the person who has victimized him. Injunction cannot be granted. And the last one is that the plaintiff has no personal interest. What do you mean by that? You cannot carry any other's baby, sir. You must fight it on your own. You cannot fight on behalf of a third party, or you cannot be a proxy for a third party. In those cases, injunction cannot be granted. And these are the 10 exceptions where injunctions cannot be granted under Section 41. Then the last section in the specific relief act is injunction to perform a negative agreement cannot amount to grant performance. Here, injunction to perform a negative agreement. I think I discussed this case also in detail. Lumley versus Wagner. The question is injunction to perform a negative agreement cannot amount to grant performs. So the question is, the positive aspect cannot be enforced, but the negative aspect not to perform during the contracted period can definitely be enforced. But one thing is this, in addition to it, you must ask for specific performance, but you cannot just file a suit for injunction alone. These are the various sections under which the specific relief act is discussed. Then we come to the important section chapter or specific performance, which I will be dealing with tomorrow. That is section 10 to 24 of the specific relief act. Thank you very much. Any questions, please? The interaction starts. Any questions, please? Any doubts?
Sir, good evening, sir.
Good evening. Yes, Mr. Sutiketa from Tirupati.
Sir,
Yes.
sir, shall you once again explain about the ingredients of injection, sir?
Yes, sir. First ingredient is prima facie case. That means a case triable on facts and documents. A such strong case on facts and documents which support your version, which you have mentioned in the plaint. That is called prima facie case. Then balance of convenience. That means the advantage that will be caused to you by granting injunction will outweigh the hardship that will be caused to the other side. For example, all the facts are in your favor, all the documents are in your favor, you have made a true and full disclosure of all the facts, and you have filed all the documents which support your claim. Then in that case, you are at an advantage. The balance of convenience, that is a triable case on your side and not on the side of the defendant. That is what is called balance of convenience. Are you able to understand, please? Third one is relative hardship. Relative hardship is the difficulty to which you will be exposed in case the injunction is not granted, in spite of having a tribal case, in spite of having a balance of convenience, will outweigh the advantage that we caused to the other side. Then in that case, on the ground of relative hardship, you can plead and prove that what is the hardship you are going to suffer if the injunction orders are not granted. These are the three basic ingredients which you have to satisfy for grant of injunction. Am I making myself clear to you, please? Yes, Mr. Sutikirtan.
Sir, third point, sir, once again.
Third
sir,
point is relative hardship. That is, in the same sense, suppose the court does not grant an injunction. Let us put it in a negative way. The hardship or difficulty to which you will be placed will be much more than what the advantage to the other side is. That is, you will have to say, I will suffer enormous loss which cannot be compensated by money. Are you able to understand, please? Yes, Mr. Sutikirtan.
Yes, sir. Yes, sir. Thank you, sir.
Right.
D. Sai Prasad Garu. Mr. D. Sai Prasad, please go ahead. If any violations, sir.
Yes.
You can ask directly, sir. Sai Prasad Garu, please go ahead with your question.
Good evening, sir.
Good evening, boss.
Sir, the violation, any violation?
Sir, if you don't mind,
the order.
sir, Sai Prasad Garu, I'm interrupting you. If you don't, please speak in English, that because people are coming from all the way from India, so that other people can understand your doubt also.
Sir, whatever disobeying the orders by the other party, adverse parties, if any arrest and detention against them, sir.
Then you can definitely enforce it by filing an execution petition under under order 21 rule 32. But if the suit is still pending and the injunction is violated, then you can file an application under order 39 rule 2A to punish the opposite side for disobeying the orders of the court.
Okay, sir. Sir.
Order 39 rule 2A.
Right, sir. Okay. Sir.
Any more questions? Please go ahead. All right, can we move forward? Or any more questions? Still have it. There is section 6. Avinash is asking. Mr. Avinash, please speak on.
Section 6 of the specific relief act.
Yes, sir. With regard to section 6 of specific relief
Yes, sir.
act, sir.
Here,
Sir,
suppose. Yes,
Just
I like.
let he wants to say something.
Please.
Please go ahead, Avinash.
yes, sir. Sir, with regard to specific relief act, suit by person dispossessed of immovable property.
Right.
In this, sir, a tenant is issued a notice by landlord under section 106 of TP Act,
Right.
transfer of property.
Right.
And the notice is issued to evacuate or vacate the property. And by receiving, sir,
Yes.
by receiving the notice, there is no reply as per the notice mandatory period of 50 days or 1 month. There is no reply from the
Right.
tenant,
Right.
and tenant never vacates.
Right.
Then without going to the suit of eviction, does the landlord has a right to throw away the...
No, sir, I'm sorry. That's why section 6 and 7 has been provided. You have to go by due process of law. That is, you must file a suit based on 106 notice and then say that the tenancy has been terminated. And even after that, he's squatting on the property. Please direct him to vacate and hand over possession to me. That you will have to go by suit.
Without going by the suit.
Now,
Sir,
I think now I understand what you're driving at. You want the police to interfere and then throw the fellow. I mean, that is in an illegal way. That is, or hand it over to mafia to get rid of a person, or remove his electric current, or remove his water supply, and then put him to all difficulties, or kidnap his daughter or kidnap his son, and ask for a ransom and say, unless
Sir, don't go in a violent way, sir.
so unless you okay, I'm not going to release.
You are giving nice ideas.
That is the reason why I'm not giving it.
No. Adhyaksha, please remove all the
That's why
everything.
section 6 and 7 has been provided the specific facts.
Sir, however, kidnap will not be because landlord and tenant will be living in the same house.
Not necessary, sir. Sir, kidnap will be worthwhile. Sir, kidnap will be worthwhile if it's a beautiful daughter on the tennis.
Sir, please.
Nice idea, sir. अगर खाली नहीं करे तो आपके बच्चे को नहीं
Sir.
All right, there is small
eviction is mandatory.
Avinash,
Yes,
I just have a request to everybody there. I have received so many calls from last so many days from various parts of India. That is from, I got a call from Jabalpur, I got from Delhi, I got from even Patna, I got even Jammu. I don't know where from my number is speculated. And so many people are asking about, please speak only in English so that I can understand it. Because we are using a vernacular English language, so that people say that please do follow it, so that I can also answer the question or I can understand the question.
Correct.
All right.
It's a global language.
Global language. That is what the request. Because I mean, maybe people are not coming into Zoom, but they have gone to this also. I mean, YouTube. So.
Following, yes, sir. Even
so please,
I have circulated the message to many of my friends. Even they have joined the session.
Thank you very much.
Sir, it is nothing but it is repetition. However, we are in practice daily, regularly. We are in practice.
How much ever practice we do, sir, we are always learned advocates.
Yes, sir. Our profession is learning profession. Even to the Supreme Court retired judge, we say learned judge.
Sir, there is a Supreme Court advocate who has called me from all the way from Delhi in the morning.
Yes.
He says
he
is just praising myself and my sister and my sir, so-called my Guruji, saying that,
yes, sir.
Sir, you brushed at least some kind of knowledge in my daily routine.
Correct, sir.
He said that I forgot so many things, but he has recollected me my college days.
That is what I am saying, sir. Sometimes what happens in practice, we miss very minute point, which will be very much helpful if we go through, sir, like people instruct us, we will again recollect all those points.
Sir, in this regard, Mr. Avinash, in this regard, I am interrupting you, sir. I still remember we came across one case where a father who lost his, wife, he used to go to his daughter's house to have food. And the evening spend his time with the daughter, and the night he used to come back home and then sleep. The landlord filed a case. He has ceased to occupy the property. But what the court said was, it said cease to occupy doesn't mean that left everything. He has to go to his daughter because he has to depend on his daughter. He is in constructive possession of the property. And in
Correct, correct.
yes, sir, in one of the Madras cases also, where prohibition was not there, liquor was available. But once
Yes, sir.
prohibition was introduced, you cannot carry on liquor trade. But the empty bottles were there in the shop. Then the question arose whether the tenant has ceased to occupy. But the courts interpreted saying that even if an ordinary waste paper basket is there, it is a possession. No question of seizing.
Yes.
So sometimes that's the word. If you see dictionary meaning, seize means stop, abandon, left, so on and so forth. Which word applies to you
Yes.
is important. The interpretation of
Yes,
it.
sir. Yes, it is the interpretation how we take it.
Exactly.
Correct, sir.
Exactly.
And, any more questions
I
from anyone?
also,
Thank you.
Vivo in
In the case where ex parte injunction is granted, whether a counter to ex parte aside, the ex
Vivo.
parte would.
So Sam want to ask some questions.
No, let that Vivo ask. first.
Vivo
Is there or not?
Vivo 2249.
No, yes, yes.
Vivo 22849. Mr. Vivo. Mr. Vivo. Are you there? My dear, you are there in the Zoom. If you are able to understand, please go ahead. Mr. Vivo. Leela Krishna, please do understand. I'll come back to you. Mr. Sam, you can go ahead with the question.
Sir, can you hear me now?
Yeah, he's
Tell me, sir.
Sir, actually, I have a question regarding the will date. Will date has been executed. The person who executed the will has been deceased.
Yes.
Okay? So, the one of the witness of that will date has become the hostile. I mean, hostile in the sense like is no more in a friendly terms.
Right.
So, in this case, what is the remedy, sir?
Sir, will is normally is called a testamentary disposition. It comes into effect after the demise of an individual, and it is signed by a person, and it is attested by two witnesses who testify to the fact that the testator signed in their presence and they countersigned it. And normally, when there are two witnesses, suppose you say one attestor turns hostile, the second attestor will be there, isn't it, sir?
Yes, sir. Yes.
So you can examine the second attestor, and you have got one more provision in the Evidence Act. I'm talking about the old Evidence Act, section
No,
70,
because
section 73.
because the yes, I'm sorry,
Section
sir.
73
Because
says the court itself can examine the signatures with the admitted documents and then come to a conclusion, irrespective of what the attestor has said.
okay, the reason because the same property is coming for litigation, sir.
Pardon?
So the same document is coming onto the litigation stage
Yes,
in the court.
right.
So in this case, in the list of evidence or witnesses, so we cannot get this person,
Yes. Or you can examine the second witness.
second witness.
Yeah.
Is that enough, sir? One in
More
each
than
witness?
one attestor need to be examined, not necessarily that two attestors should be examined. Sir.
Okay,
And
sir.
you have to be very, very careful in leading the attestor's evidence. You know, in Telugu they say, come and oche kote, that means finish up the job.
Yeah,
Don't go
sir.
into
No Telugu,
don't
no
go
Telugu.
into details. Only say, have you seen the signature? Yes. Do you identify the signature? Yes. And have you countersigned it? Yes. When did you countersign it? After the testator signed, I countersigned it. That's all. Don't go into the facts.
Okay, during cross-examination, sir.
But
Is that
sometimes,
what
yes,
you're
sir,
doing?
sometimes, no, when examining him in chief, but sometimes what
Okay.
happens is the attestor talks much more than what the actual party says because he's been brought for a song.
Okay. Yes, sir. So one more thing,
Yeah.
we have a property in Hyderabad.
Yeah.
The document is missing, 1969. We don't have the document number.
Right.
So Red Hills, I think the sub-register is in the Red Hills, right?
Right.
Somewhere in Nampally. So how do we obtain, sir, without the number?
If you have the registration number, you can make a search. You can make a search and get it.
Sam,
We don't have a number, sir.
Sam, would you like to give me a call? You have my number on it.
Yes,
So
sir.
that I'll
Yes,
let
sir.
you know
I'll
what
give,
to
sir.
do, what to do.
Yeah, sure, sir.
You have my number, I hope so.
Yes, sir. I
Please
do.
do
Have,
call me after the class. I'll tell you what to do.
sure, sir. I'm practicing in Mumbai, sir. That's
All
why
right.
I cannot come.
I'm from North, sir.
Okay, sir. Thank you, sir.
Thank you, Max. Sam, please be on the hold. Anybody else? All right, shall we wind up? Any more questions now? Leela Krishna Garu, please go ahead.
Sir, good evening.
Good evening, Leela Krishna garu.
Sir, I am not involving into the subject line to mention any queries about it.
But personally, I would like to appreciate for the sessions since so far it is happening. Because the way the Dharma Legal is churning your generations of experience together, we are literally enjoying the essence of your experience and everything.
Sir, the credit should go to the admin, sir, who prompted me to have these lectures.
I offer him personally a chocolate.
Your friend,
Once I met
Mr. Srinivas Kalyan.
Nothing. Always with you.
My side.
Thank you. Any more questions? Please go ahead. Mr. Prasad Garu, any questions you have? Prasad Rao Garu. You're just clapping, I hope so.
Yeah. Good evening, sir.
Good evening. Any
I
questions?
also want to reiterate that these classes are very helpful, especially for those who are, not really fully practicing, but out of curiosity and to learn more. Sir is covering even some of the basic things, and not only bookish knowledge, but I find even the practical knowledge, which some of the things are not available in the books.
Sir,
But out of practice, do people really go to courts? Those things also, sir is really explaining. That is so helpful for us, especially sir is going to the ground level. Even the basic people are able to understand.
That's what
and
that's
then
what
they get
is.
the confidence.
The experience
We get
counts,
the-
sir. Is the experience counts.
Really.
Thank
So I
you.
was clapping for him and
Thank you.
for
Thank
you
you.
also. Thank you so
Thank
much.
you very much. Anything else? Any more questions related to the subject? Please go ahead. So that we will. So,
Sir, good
Mr.
evening,
Satyagar.
sir.
Please go ahead.
Satyabut from Karimnagar.
Sir,
Sir.
regarding the sir, good evening, sir. Good evening. I'm Karimnagar, sir. I'm from Karimnagar.
Please go ahead, sir. Please go ahead, sir.
Sir, coming to that regarding the filing of the out of order petition, sir,
Yes.
whether apart from the CPC 151, also that whether it can be filed under the civil rules of practice under 257, I think, sir.
It can be
And
done.
also,
It can be done, but your forms which are available is 151. Read with, you can say.
okay, sir. So thank you, sir. Thank you, sir.
Thank you, sir.
Just one more submission, sir.
Please go ahead, sir.
So regarding to that, when I go to the review succession, right, there is the column is there, the succession by inheritance and succession by survivorship, sir.
Sir, survivorship has now been abolished, sir. You don't have survivorship now. After the Succession Act was passed, that is what is called law of primogeniture. Whoever was the eldest member or the survivor succeeds to the entire property. That is called law of primogeniture. But that has been abolished by the 1955 Succession Act. Now it goes by succession only.
Okay, sir. Thanks, sir. Thanks a lot, sir. Thank you, sir.
Welcome.
Sir, shall you explain what is out of order, sir?
Out of order means where you want your suit to be taken urgently before going to the other matters, sir. That is called out of order. Out of order means as a special case. In High Court, we call it as lunch motion, and in Bombay, it is called as what is called chamber summons. Are you able to understand, sir?
Sir, once again, sir.
It has to be taken up immediately with because the matter of such a grave nature, where you want interim orders immediately on the same day. That is called out of order. That is without a full trial. You want the orders to be passed immediately when there is a grave danger to your rights.
Okay. Thank you, sir.
Anything else? Any more questions? Or shall we conclude the class today? Mr. Ravi, I'm not able to understand.
Sir, namaste.
Namaste.
Sir, in NI Act 311 petition was dismissed in lower court.
311.
But the next step,
We are not dealing with criminal law, but anyhow, I tell you since you have raised it, 311 is recall of a witness in criminal side. But as far as our CPC is concerned, it's order 18 to 17, recall of witness.
yes, sir.
We'll see. We'll give a snap of it.
I'm asking criminal procedure.
Criminal
Yes.
is the recall of a witness who has been examined where you don't have your cross-examination. You want the witness to be cross-examined. Then what's called recalling that witness for cross-examination. That is called 311.
Okay. Yeah, in lower court already dismissed it, sir. So
Then
how can I put
you can file a revision against that order before the Sessions Court.
in Sessions Court
Yes, sir.
or in High Court, sir?
High Court or the Sessions Court, as the case may be, sir. If it is the district court which has dismissed it, then you can go to the High Court. But if it is the magistrate who has dismissed it, then you can go to the Sessions Court.
Thank you, sir.
Great, thank you. Any more questions? Please go ahead.
Sir, what are the documents should enclose with the plaint, sir?
Sir, the documents which are called suit documents, sir. The foundation of your claim, like your sale deed, then the necessary documents like payment of tax, payment of the land revenue, your Pahani Patrikas or whatever it is, and then the encumbrance certificate, valuation certificate, so on and so forth. You cannot enumerate it. Or what is the foundation of your claim is called suit documents, and that has to be filed. If you take a money suit, it is a promissory note and receipt, then the notice which you have given, the reply which you have received, the acknowledgement which you have received, and the correspondence you need not file. But these are called suit documents. They have to be filed along with the suit. You can either file original or you can file certified copy and say, originals are filed in some other court, I'll file it later.
Yes. Any more questions, sir? Can we conclude the class for today? Last announcement, sir. Any more questions? Please go ahead, sir. Otherwise, I will conclude the class today as of now. All right. Thank you much, and we'll see you tomorrow again.
Specific performance.
On specific performance tomorrow. Thank you.
Madam, sir, what are the matters where injunction cannot be granted? Then the damages in lieu of